Good afternoon, everyone, and thank you for joining us this afternoon. We're just going to wait a couple of more minutes for more people to join in on the call. Thank you, and we will officially start just in a few minutes whilst we're waiting for people to log in. Thanks. Okay, good afternoon, everyone, and thank you so much for joining us. We are going to start our webinar for this afternoon, and anybody else who joins us along the way will find us where we are. My name is Nobukosi Zulu, and I am the Knowledge Production and Capacity Strengthening Manager at ISLA, and I am so excited to have you joining us here today at the launch of two ebooks and a manual guide from ISLA on human trafficking. One is on human trafficking a guide on human trafficking cases, and the second one is a trauma-informed survivor-centered lawyering standards manual. And we are so excited to have you join us. As the conversation goes, you'll be able to see in our chat box links for you to be able to download our guides, our ebooks. Please go ahead and do so. It is so rich. It is both of these pieces of work are absolutely exceptional, and I'm very excited to have everybody here joining us, and I'm going to give our panelists an opportunity to introduce themselves whilst we start. And I'm just going to start with Dr. Ruth. Dr. Ruth?
Sure, thanks Nobu. Welcome everyone. It's wonderful to have you here. My name is Ruth Nekura. I'm a human rights lawyer. I'm a feminist social legal researcher, and I also work as ISLA's legal director, which generally means I support work around building partnerships for social justice, capacity strengthening work, and knowledge production, which is the research work that IFLA does. And I'm ecstatic to be here.
Thank you, Dr. Ruth. I'm going to ask Professor Joy to please introduce herself as well. Professor Joy, you are on mute.
Thank you. Thank you. My name is Joy Ngozi Ezilo, Professor of Law, a feminist activist scholar, and the former United Nations Special Rapporteur on human trafficking. And yes, I'm involved in the trafficking and human rights work around the world, and I live in Nigeria. Thank you.
Thank you, Professor Joy. Sophie, please go ahead and introduce yourself.
My name is Sophie Otiende. I work for Liberty Shed. I'm a feminist, I'm a survivor leader, and also doing a lot of work around protection and inclusion of survivors.
Thank you, Sophie. Thank you, Sophie. Jacob, could you please introduce yourself?
Yes. Thank you so much for having me on this panel. My name is Jacob. I'm the program, I was the program manager at HEART for 7 years. And now I have another title, Senior Strategic Advisor. So while I was a program manager, I was involved in all the different aspects of dealing with human trafficking, from prevention to protection and advocacy and legal research, all these things. Now I'm more involved in providing advice for the organization.
Great, Jacob. Thank you for joining us here. And so today we are launching publications by ISLA, as I've stated. We're all aware that human trafficking is such a huge problem, particularly on the continent. There is a clear lack of conceptual understanding of what human trafficking is, and there is definitely failings in offering a holistic approach to how we deal with these cases. And so today, my first question is going to be for you, Professor Joy. As the special rapporteur, you did a significant amount of work expounding on normative standards and state obligations when it comes to human trafficking. In your opinion, what aspects of state responsibility should a lawyer or NGOs pay attention to when they're planning to litigate a human trafficking case?
Yeah, thank you very much. I don't know where to start. It's a huge question, but very important one. And I'll try to do it within the context of the ebooks we are launching today. We know that when we talk about standards and human rights standards, especially in the context of human rights and trafficking in persons, then you look at the legal frameworks, the normative framework, and then what are the key principles to emphasize there. And I think here is the issue around the right to effective remedy. And I spend an enormous amount of time expounding on that. And the concept of due diligence, and this due diligence founded and grounded on international law. And when I say international law, I also mean regional laws within the African system. It is a well-established doctrine of international law that the state has an obligation to redress wrongs when act or omission is attributed to the state. And here the state includes both the agents of the state and organs and all those who are responsible. So within that context, they have also obligation for conduct of private, but not for conduct of private person that is not attributable to them, but also for failure to take certain action. And here, within the context of trafficking, the due diligence or the concept of due diligence is about government or state responsibility to prevent violations. Because human trafficking results in cumulative breaches of human rights. To prevent violation, to investigate, to prosecute, and of course, to protect. trafficked persons or potentially people at risk. So it is very important within that, looking at right to effective remedy, to make sure that human rights of victims of trafficking is placed at the core of any intervention by the government to prevent and combat human trafficking. First, you look at the international, for a lawyer or NGO, the international and regional treaties that the state party is a member that prohibits trafficking, slavery, similar practices, and protects human rights. And then, of course, you look at the Palermo Protocol, though not very much rights-based, but just like I stated, when it comes to human trafficking, all the other normative human rights frameworks are activated. First, so the human trafficking and related exploitation, you have to make sure they are criminalized in the country's context. And even with regard to domestic application of a UN protocol, it may not matter even if the state didn't ratify it. Some of the provisions there are part of jus cogens. And then again, some of the due diligence principles and rights to effective remedy are already foregrounded in many other international human rights treaties. But it's important also to note that the UN protocol, for example, the protocol to prevent, suppress, and punish trafficking in persons, especially women and children, which supplements the United Nations Convention Against Transnational Organized Crime, is not self-executing. And states, as part of their obligation, are required to transpose it, to incorporate it into domestic system. So that's an international obligation. And failure to do so is also part of breach if they are a state party. So the state exercising due diligence that the government did not fail in its obligation to prevent or prosecute traffickers or take any administrative action. And here we have jurisprudence. And one of the earlier cases, the case of Ranzev against, I think, Cyprus and Russia, is the locus classicus, a landmark that espoused that obligation and what it means when state parties are held accountable for failure. For example, to take necessary, appropriate administrative and other action to investigate human trafficking acts. So again, you look at Article 1 of the, Article 2, I mean, and Article 6 of the protocol that talks about the kind of assistance that states are obliged, the state parties, to provide to victims of trafficking. And then it importantly states that state parties shall ensure that its domestic legal system contains measures that offer victims of trafficking in persons the possibility of obtaining compensation. And this is also part of a lot of the work I did. And I think also this is part of the beauty of the current guide and manual and the care on trauma that ISLA has put together with HART. You see, for a lawyer or NGO, you should look at the gaps in government responsibility, where they have failed to exercise that due diligence to protect persons within their territory from being trafficking, and also steps that will ensure accountability to traffickers. Have they failed? If this is gross abuse going on, and then government's attention is called to it, and they fail to even identify persons who are potentially trafficked persons, then also they are not exercising the right due diligence. The frontline officers, immigration, police, who are supposed to care, including those who will do the referrals, if they are failing or turning blind eyes or not wanting to do their obligation to protect the rights of persons who are trafficked or possibly could be trafficked, then they are not exercising that due diligence. So it's a state responsibility, and states may have obligations under specific treaties to provide remedies in addition. And that's why I said it's all encompassing, and we have to look at both international and regional treaties. And I think for us in Africa, we look at our own regional human rights treaties, African Charter, the protocol to the African Charter on rights of women in Africa. So once that state responsibility to provide trafficked person with remedies is established, then we then begin to talk about content of specific remedies, which I won't go into, but these are things I think a lawyer, for a lawyer, it should be important, or NGO service provider, it should be important. And then there is a whole lot of guidelines, and which is also already explained in the guidelines around restitution, compensation, rehabilitation, and some of the things that are expected to aid recovery, and then also access to justice for victims who are seeking redress. Thank you.
Thank you, Professor Joy. Thank you so much for such a wholesome answer. And I think that is something that when it comes to human trafficking, the idea of what exactly are the state obligations, and even though sometimes the state obligations are spelled out in clear black and white, as you have highlighted in regional and international instruments, and in some places in their own national instruments, states still fail to be able to apply them in a way that is meaningful and actually allows the survivors to get the justice that they deserve. And I think part of that comes from the problem of how do they conceptualize human trafficking, and how do states actually understand what human trafficking is? And then oftentimes they don't understand some of the nuances and some of the issues around the genderedness of human trafficking. What does it mean to engender a human rights approach to human trafficking? And how can lawyers and NGOs use this guide to do just that in order to ensure that states are able to meet their obligations?
Right. Thanks, Nobu. I think it's a really good question. Engendering a human rights approach to human trafficking, and just taking up from what Professor Joy mentioned, the main global UN Convention on Trafficking in Persons is actually not a human rights treaty, yeah? So it's a protocol to a convention on organized crime, on transnational organized crime. And if you think about the ways in which laws are made and how conventions and treaties and how standards are formed, it's also about the mechanisms that form them, because there are ideologies that inform the ways in which those mechanisms operate. So the work that Professor Joy has done, during her course, and even the mandate has done, is really to try and merge these two ideas of saying that, yes, human trafficking is a crime, but also it's a human rights violation. So what that means is doing the work to mostly two things. When you talk about a human rights approach to human trafficking, if you look at a very basic level, it's two things. One, it's thinking about what are the rights of the victims of human trafficking, what are the rights of survivors, and identifying survivors and knowing survivors that have experienced human trafficking, but also communities and population groups that are at risk for human trafficking, and thinking about the rights that are held there, and then about the obligations and the duties of states. So what are the corresponding obligations of governments? So that's usually the two ways to think about a human rights approach. But of course, we know that a lot of rights are violated in the context of trafficking. We know the right to life, liberty, security, freedom from violence from private or public sources, depending on the kind of exploitation, or the purpose for the exploitation that was in every specific case. It could be slavery, servitude, freedom from forced labor, bonded labor, freedom of movement, association, adequate standard of living, for children specifically, rights around special protection, discrimination, broadly speaking. So there are many rights that are implicated in a human trafficking situation. So doing a human rights approach, and what the guide helps us to do, or it helps lawyers and NGOs to do, is to situate human trafficking within the ideologies and the discourse of rights, to say, who's the victim in this particular situation, what are the rights that have been violated, who are the duty bearers. And when we're talking about transnational organized crime, because trafficking is not always transnational, but when it is, then there are many states that are involved. It's not just one. There's the state, the source, the receiving state, and if there are transition states in between. So it can be more than one state that's responsible, in any one case. So really, the idea of doing a human rights approach, the purpose is so that we can go deeper and broader than just the criminalization element. And this is important because especially the conversation on effective legal remedy. So what does a good, effective, adequate remedy mean for a survivor of human trafficking? That's why a human rights approach is important. So what the guide does is to try and use the standards and the guidelines that exist internationally and to unpack, giving examples as to what would be an effective remedy for survivors of trafficking. And beyond that, going to the actual working with lawyers so they can be conscious of the root causes of human trafficking. So it's not just the manifestation of the violence that has happened, but to think about what are the the drivers of trafficking, what are the vulnerabilities that are often intersecting and therefore predisposing certain people to higher risk of trafficking than others, for instance, and then identifying the barriers that might stand in the way of access to justice and guiding lawyers on how to overcome this challenge.
Thanks, Dr. Ruth. I think what you highlighted is when you identify, it's important to identify who the actors are and what all the obligations and what the people need in each character in this unraveling of this in a human trafficking case. What is their responsibility? What do they bring to the table, and understanding that? And often when we're talking of things that involve a criminal nature, far too often we often consider the state and the perpetrator, and survivors are left out of conversations, and they're just standing by and just watching the system unfold. And I'm so excited to have the next panelist speak, because for you, Sophie, as an activist, a survivor, and an advocate for survivors of trafficking, you have vast experience in human trafficking case management and how it actually interacts with the legal system. So in your experience, what are some of the needs of survivors? What are some of the immediate needs, the intermediary needs, and some of their long-term needs as they navigate the system?
Thank you so much. And thank you so much, Ruth and Professor Joy, for actually laying this out for me and making it very easy for me to answer the question. So I think some of the things that Ruth actually has pointed out, in the sense that we have a system that doesn't, or even a law that hasn't really thought about survivors, essentially, and what their needs are. So first of all, what I'll say is that for any person thinking about doing care work, being very intentional about asking survivors what they need is really important. Survivors define justice differently. One of the mistakes we've also done is like sort of blanketly put every survivor in one box and basically say, this is what they could possibly need. Survivors need differently. When need different things at different times. But back to your question on, at the beginning, of course, you're going to have to look at the condition of someone and the impact of trauma on them. Do they need housing? Do they need a shelter? Do they need transport to just go home? Do they need a place to just lie down for a few minutes? Do they need psychosocial support? We have the fact that most traffickers actually target people that are vulnerable. So also thinking about the individual vulnerabilities of a client and what do they actually specifically need. If you're working with someone who comes from a minority group, thinking about stigmatization and how you actually address that and fighting for their rights is something that you have to think about. So psychosocial support and trauma support is really, really important. And then also thinking about like just culturally sensitive care. And I think that's something else that we don't think about, that we come and present our needs very differently culturally. So also in the long term, like what culture are you dealing with, and what specifically, how will this person find belonging and community once they are reintegrated back to their community?
Thank you, Sophie. I think it's exactly what you've said, really. Taking our survivors and being conscious of what they need. And unfortunately, for most parts and for most practitioners, they don't have access to this type of information. They don't know where to look. They don't understand the legal system around it, and they don't understand even the ideas of offering holistic care. So for you, Dr. Ruth, this guide, it provides a step-by-step for litigators on human trafficking, and it integrates a lot of the learnings that ISLA has through partners and through key people such as Sophie and Professor Joy. How does this publication differ from other resources that already exist on human trafficking?
Right. How does this guide differ from other resources that exist? I think that, the purpose of this guide essentially was to assist ISLA's network lawyers in effective first identification of human trafficking cases, because a big part of ISLA's work around strategic litigation has been about thinking about the gaps and the challenges of just sourcing cases. So I'll give an example. We know that even just from the context that this guide provides, that the reality of human trafficking on the continent is rife. And yet when we look at our jurisprudence, there's very little on the continent, that's coming out of courts. So there's very few cases that are coming for litigation, for constitutional litigation and strategic litigation in particular. And the question for ISLA has been, why is that the case? Why aren't lawyers, bringing these matters before our regional mechanisms, whether it's the African Commission, the African Court? Why is there that, discrepancy of, you see very many violations on the ground, but then in reality, very few cases are coming forward. So the purpose of the guide really was to assist ISLA's network lawyers, the feminist litigation network lawyers, more specifically when they are trying to identify human trafficking cases or developing these cases for strategic litigation, to effect some form of social transformation using the courts. And specifically when it comes to the context of human trafficking, the guide seeks to ensure that litigators can, understand the standards that Professor Joy was speaking about and how to use them, but also how they can interact appropriately or, in a constructive way with their clients and with other role players. What the guide does is it provides really detailed guidance on even non-legal issues that occur when you're trying to litigate a human trafficking case. So there's very specific information around care and protection, assistance practices that are arising from experiences of organizations that have supported survivors of trafficking. And there's also a lot of guidance on just how to support trauma victims. Because the guide was both desktop and empirical, then it gathers a lot of experiential data, even from Sophie, who's actually joining us today, and her colleagues. And we also spoke to Willow International, who we're so grateful for, really to get those lessons that have been learned around, in the process of seeking justice or reparations for victims of trafficking. What does protection, assistance, practices, best practices for assistance and protection, what do they look like? And then there's also a lot of rich information around conceptualizing human trafficking itself from a feminist and Pan-African perspective, because again, there are contested ideologies around trafficking. We spoke about the crime-oriented approach. There's also just like the immigration way of thinking about human trafficking, right? Which is to think of it and conflate it often with migrant smuggling, and the interventions then become stricter border control and things like that, which is fine. But I guess, as is, of course, all approaches are necessary, for a comprehensive intervention. But ideally, when it is what the guide does is to unpack the dangers of narrow conceptualizations of human trafficking, even the moral conceptualization of trafficking, where we've seen a lot of conflation on, trafficking, exploitation for the purpose, trafficking for the purpose of sexual exploitation, and then how it's conflicted with sex trafficking. And then there's sort of an anti-vice movement, and resources are diverted, instead of fighting trafficking, then it's, criminalization of sex work, and what that narrow approach also does. So the idea for the guide really is to present for the lawyer or the NGO all of this various conceptualizations around human trafficking, and then say this is how you identify a case, because it's also difficult to see these cases, and when it comes, this is how you develop your case. So it's intended to be read, of course, alongside other literature and resources and case law on human trafficking, but really as a starter pack for the litigator or the lawyer who just wants to know what's the best way to build a case and to build it holistically.
Thank you, Dr. Ruth. That's a really good appraisal of the guide. And to quote Victoria, who wrote the foreword, is that, this guide could be considered a Bible of sorts for practitioners who want to work in human trafficking, because it is so comprehensive, and the lived experiences that are recorded there, the clear articulation of the different laws and norms and standards that are required, the case precedents that are in there. It is really a useful resource that every practitioner should really have a hold of. But my question for you, Professor Joy, is, in this, you have a guide like this, you have the resources. In your experience on the African context, what are some of the persistent gaps and challenges in protection of human trafficking victims and survivors? And I would stretch it to say, what are some of the challenges that litigators, face? Everything is there, but what are the persistent challenges on the continent?
Anyway, first on the guide, I think it fills in an important gap, because capacity gap is where the problem is. And even for the practitioner, for the litigator in Africa, it is a problem. So to that extent, this book is a significant contribution in addressing those capacity gaps and bottlenecks, the challenges around VOTs, trafficked persons in search of justice. Is a very comprehensive guide that every practitioner, lawyer, and even non-state actors involved in litigating trafficking and pursuing justice for trafficked persons ought to have. So with this manual, I think if it follows a guide that if a lawyer follows, they are likely to obtain what for me is important, effective remedies for their client. It is rich in content. It will help a lawyer build a very good case for client. It is victim-centric, and this is also part of where I've seen the gap. Victim-centric, using human right-based approach. The international normative standards and case jurisprudence that will aid litigators are all part of that in pursuing strategic litigation, whether at national level, municipal level, or regional, within the regional system, or international level. I think in terms of this, again, the issue of the gaps and challenges, I'm still talking about that, is the absence of victim-centered approach. Especially, often we think that if you're talking about criminal justice, and you're all thinking about prosecution of traffickers, and then even use of trafficked persons or victims or survivors as a means to that end, like an instrument in the criminal justice system. And we're not looking at them as also, people with agency, and for which a form of justice is a form of care that need a redress, and then need a compensation where restitution is not possible, and other form of assistance because of the wrong they have suffered. So absence of human right-based approach and understanding of this normative framework, particularly for lawyers, because people are not, I can remember I teach criminal law, so my student would be lucky, but I teach human rights, I teach criminal law, I'm able to incorporate issues around trafficking in person. This is not what people or lawyers who are being trained are ordinarily taken through in their coursework. It's just beginning to emerge. So recognition that trafficked persons have suffered cumulative breaches of their rights as victims or survivors, and that this right needs to be addressed. There is no institutional arrangement even the anti-trafficking measures don't take care of that. And for the lawyers, the confusion was always around Article 3. What comes within definition of human trafficking? How do you unpack? You know, there are a lot of things that compound even that definition. Issues around consent. And people will say, oh, but they took that job, so they gave consent, but they didn't consent to be exploited. So what about the level exploitation? How do you distinguish the different types of exploitation that may not be part of exactly trafficking? The issue of slavery, servitude, forced labor, the concept of vulnerability and abuse of position of power. So these are things that ordinarily for prosecutors, I mean, they are trying to secure conviction. It might be easier. And then for the victim, they are not thinking of compensation for the victim, or the way that it will also take into particularly even the reprisal attacks or witness protection and other things that they need and the kind of support they need. So these are areas now that lawyers will have to start looking at. And we have jurisprudence, after all, International Criminal Court, the Rome Treaty also, they provide this type of support. It can go not just in a civil, it can go in the criminal case, and it's possible now within certain domestic system that even victim could be awarded compensation, and that is the ideal. This is one of the things I advocated for during the criminal proceeding, and not allow, they are finishing the criminal proceedings and then going back to start asking for compensation in a different civil action. But I think for lawyers, they need to know how to build a case. They need to be able to understand the Article 3 definition of trafficking, what comes within that. They need to distinguish trafficking from other phenomena, including exploitative conduct that may not amount to trafficking exactly. So appreciation of that will enable them also, using also their domestic, the penal laws in their country, and then other human rights standards to be able to make a good case and then get compensation, including restoration of rights of a person's clients that they are representing. And I think this is what is very important. And to that extent, this book filling an enormous gap that I see already, and that is a capacity gap, the lack of coordination, referral, and working together for litigators. And so people can pick it and know, oh, I can contact this person. I can also see how this has been done. And then there are persuasive authorities and jurisprudence elsewhere that they can use. So yes, I can go on and on. I'm trying to, I'm looking at time, and I know I don't want to take a whole lot of time to talk about this. Thank you.
The issues, we could also listen on and on. Your explanations are captivating. And thank you so much for synthesizing and breaking down concepts that can seem so big around the legal institutions and all the things that people have to understand in terms of human trafficking. And you explain it very well. So the temptation is to let you go on and on, actually. So I think this guide is so useful, as you have said, and it attempts to address, it does address some of the capacity gaps that are found that a lot of practitioners don't have, and the knowledge gaps as well. And as we have stated, one of the people that really was instrumental in making sure that this work is actually meaningful and it's not just an academic exercise that doesn't speak to the reality on the ground is the experience of Sophie. So for you, Sophie, through Isla's interactions with you, Isla learned so much about trauma-informed approach and a victim-centered approach. Could you please just explain to us what is trauma-informed care and why does it matter so much that you use such an approach when it comes to human trafficking?
Oh, thank you so much. Like you, I'm tempted to listen to Professor Joy forever. So I think trauma-informed care, one of the things that you to recognize is that the impact of any abuse is trauma. Of course, not every single person that goes through abuse is traumatized, But most people, when you go through abuse, you go through trauma. And in addressing care, you really need to think about the impact of trauma. And trauma-informed care is just focusing on the impact of trauma on a person when you're providing care. We talk about the 4 R's of trauma-informed care. You realize the impact of trauma, and basically by realizing the impact of trauma, you use that to understand the paths to recovery. So, for example, if I have been sexually abused, the impact of that abuse and the trauma as a result of being sexually abused will make me, as the person who's providing you care, think about all the different things that I need to think about. For example, I need to think about, you being tested for, whether you have an STD. I need to think about, was this someone you knew, or was this someone who's not, who you don't know? So you need to actually think about that impact and then sort of design the pathways to recovery based on that realization. The second thing is to recognize the signs and symptoms of trauma. Most of the time, we come from a system, and the development system and how care is set up right now is that there's an expectation that survivors should be grateful for actually being taken care of, grateful for anything that they get, in terms of service provision. And any survivor, having worked with different organizations providing care, any survivor that is seen to be angry, that is seen to be, aggressive in any way, is usually not treated well. And that's just a misunderstanding of we all don't show trauma the same way. Some of us will cower, some of us will want to sit still, some of us will want to fight back. So recognizing the signs and symptoms and actually understanding when someone is behaving in a certain way, knowing that it's because of trauma, it's part of trauma-informed care, and then responding with effective techniques, knowledge and practices. And this is where I speak a lot about the fact that we have such a severe complex system in the counter-trafficking sector, where a lot of the people that are responding to trauma don't even have the techniques, don't even have the knowledge, are not even equipped to provide care. Many people just want to save survivors, and it's not your responsibility to save survivors. Responding to trauma actually requires knowledge and practices that have been tried and tested, and avoiding re-traumatization. I'll also speak about the fact that we also have this system that, because survivors are not involved, most of the time when people see survivors, they think about people who are victimized, who can't take care of themselves and need to be taken care of all the time. And we really, really don't talk about post-traumatic growth, which is that some survivors actually learn positive things and grow from trauma. So that can actually be used to advocate, to fight, to build a movement, and to actually work on these issues. So for me, trauma-informed care encompasses all those things: realizing, recognizing, responding, avoiding re-traumatization, and above all, recognizing that survivors have the capacity to actually use trauma for good.
Thank you, Sophie. Thank you for teaching us and for bringing us with you to understanding what trauma, what it means and what it can be used for, as opposed to just, the idea of a victim. And I do think that a lot of practitioners and litigators are not always aware of the savior complex, right? Of understanding that even though people are coming out of what has been a horrible situation, they are agents in their own stories, and they still have capacity to be engaged in those processes. And so I think that what you've shared is then what makes my next question to Jacob very clear. And Jacob, my question for you, as someone who worked with ISLA, what would you say is the value of the trauma-informed survivor-centered lawyering standards that Isla and Hart worked on putting together.
Thank you. Yes, I think one of the values of this type of this manual is that it provides kind of a framework of giving a more survivor-centered approach to providing legal aid and assisted prosecution for victims of trafficking. It at least in my experience, it's been like this kind of disparity between protection of survivors and then prosecution. That doesn't always keep the survivor's interest at heart. That in the sense that the way and I think this is something that was mentioned earlier, the way the Palermo Call have been set up, it's been focused on the crime aspects of it, of the criminal justice of it, which in many cases is very, very difficult, even under the best of circumstances, because of the difficulties in getting evidence and all these different things. And survivors are there just expected to comply with it. And this type of the standards now helps to provide these kinds of more holistic approaches, where you also ask the question of, what does the survivor want in this? Is this something they want to participate in? So we had this experience a few years ago where survivors in Kenya were essentially being forced to participate in criminal proceedings that were compromised. So they were not safe. So when it comes to human trafficking, it's such a broad concept that there are many different types of cases. It goes all the way from, you know, familial trafficking, where you are taken to your rich uncle in the big city, or to transnational organized crime, where it's like very, very high level cartels that have up to the very highest level of governments and business interests and all these different things. So when you have some of the latter, and you have a system that doesn't provide protection for the survivors, you don't have, you're never going to get a proper experience and a proper protection for these survivors, and you're not really going to have a good chance of prosecuting the perpetrators, because the survivors are not going to comply. So even what happened in that case was that they were being threatened they had to participate, even though while they were receiving these threats, the following day they received the same opposite threats by the perpetrators network. So while it is important, of course, to have justice, and in the legal sense, of course, it is also important to look at what is realistic, what is and make sure that this whole process is based on an informed consent. So at least the way I see it, the number one priority should be ensuring that the victim is safe, is protected, and that traumas is being addressed. And then the second part is looking at the different legal aspects of it. And sometimes that involves, you know, you could do civil litigation, but you could also even have the process, you know, if you're in such a case that poses a direct threat to the survivor, then it's actually more about protecting the survivor from the legal process, rather than trying to attain this justice that is just not realistic. You know, when you have cabinet secretaries who are involved, and you have different governments and high level business interests. So in these cases, it's trying to kind of create a standards where the survivor is at the start of it. And it's just something I've been trying to talk about for some time, that if you want to have any chance of ever getting prosecuted, like, and I'm not talking about prosecuting the security guard who worked at the brothel or whatever, but like prosecuting the people who are actually behind it, the people who are profiting from these things and all that. You need to protect the survivors. that's the only way they're ever going to be able to feel safe enough to give evidence, because the disparity in the power balance between a trafficker and then especially these high-level cases is just enormous. And you need some kind of protection for the survivor if you're ever going to have a chance of getting it. And this is not even just an African issue. Like, we saw what happened with Jeffrey Epstein, right? This is a very high-level trafficking cartel, and no one has been brought to justice, even though it's most likely thousands of victims, and many of them have spoken out. So this is something that happens all over the world. But the protection of the survivor should always be at the forefront, whether it's a high-level case or a low-level case, because you don't need a lot of, the power balance is always going to be in the favor of the traffickers. So yeah, so I think maybe to sum up, it's trying to bridge the gap so that the people who are supposed to be on the survivors' side, that they actually have some of the tools that they need to be able to do that.
Thank you, Jacob. Thank you so much. And I think that your answer leads me to my next question for you, because you've already given us really, some of your experiences with human trafficking as HART. But what are some of the examples of trauma-informed survivor-centered lawyering that you've seen, and what is the best way to implement these approaches?
So it is not easy. That's the starting point as well, of course, because like when a survivor, let's say, is rescued by the police, or say a child is brought in by the social protection services or whatever, they're already in contact with the system, and you can't just you shouldn't just protect the survivor from the perpetrator, but also from being traumatized through the bureaucracy and the problems that happens within these systems. But I think some of the key points should be always have managing expectations, so that the survivors understand this is what to expect, this is what could happen, these are the risks, so that they don't have, like, of course, sometimes survivors have this they have this kind of passion. They want to see justice. They want to have someone go to prison and all these things. But you also have to be able to provide them, okay, you want to participate through this court process, but these are some of the pitfalls, these are some of the risks, and this is what to expect, and how, let's say, this is the time commitment that you could expect from this. Then you should have proper and clear communication, so that they speak the same language. Of course, lawyers are highly educated, and a lot of times the survivors are the most poor and vulnerable. So in many cases, they don't really understand the legal jargon, which even someone like me, who's not a lawyer, struggle with as well at times. So providing them with this kind of risk management and time expectations and all the different aspects of it, and then not just provide it in a vacuum. You have to provide it together with the protection services. You can't expect someone who is still deeply traumatized to be able to go and testify in front of the court and then not have any issues. And then also this finding out what is the definition of justice for the survivor. Is it something that they actually want? Do they want to go through this whole process? Because at the end of the day, it should be about what this survivor wants and what they need. And then the other thing is just that when it comes to these things, you also just need like very passionate people to be able to go through this, especially in countries with broken justice systems. You need people who are willing to really to be able to walk together with the survivor. And then I think also in a broader sense, there's a need for much more training and advocacy to also improve the coordination and the cooperation between the different actors in this space, because however well the lawyers will be, you still have to deal with police investigators, you still have to deal with judges and magistrates and prosecutors and social workers. So there's a lot of different people who's going to have an impact on how this could be. Or let's say the media. Maybe another example was that in one case, the survivors had already seen how survivors from a previous case had been treated. So they were already concerned about what was going to happen to them. And a lot of times the people they want to be able to show, whether it's NGOs or it's police or whatever, they want to show the world that, hey, we are successful. Look at all these people we have rescued, and look at these horrible traffickers that we have arrested and all these things, but without concern to protecting identities and having informed consent and all these different things. So these are also things that I think lawyers could be able to start also holding some of these people to account, because it really takes the whole process if you're going to able to start to make a dent into this type of crime, because it's really like very, very few cases that end up with successful prosecutions, and where you're able to remove that threat from the community. So let me just see my notes. Is there anything that I missed? So yeah, so no, so maybe just to sum up, it's just to have some kind of a cross purpose between the survivors at the justice, and then also the general, let's say the benefit of the community as a whole, in the sense that now we want to remove this threat from the community, but you can't do that at the expense of the survivor.
Okay, thank you so much, Jacob. I think you've given all of us a lot to think about, and I particularly like exactly what you said, and which is essentially what you really expanded on, is that if you want to have successful prosecutions, if you want the criminal justice system to function in the way that it's supposed to, if you want to give meaning to all these provisions and legal instruments, you have to place the survivor at the center of the story. You have to protect them, you have to take care of them, you have to make sure that they actually are able to participate meaningfully, because otherwise a lot of these perpetrators are let go and are able to continue their reign of terror, because the criminal justice system failed to recognize who was actually the most important player in that. And so now I'm going to open up our panel for questions from our participants who are joining us. If you can see, you are more than welcome to raise your hand. If you raise your hand, we will unmute you to take your question, or you're welcome to type your question in the chat box, or there's also a section that says Q&A where you can type your question there. Please feel free to ask your questions. There are no right questions. All questions are welcomed, and it's an opportunity for all of us to learn. But whilst we're waiting for our questions from our participants to load, I'm gonna come back to you, Professor Joy, and ask you, based on everything that we've been hearing today, in your estimation, what is the potential for strategic litigation in human trafficking, and what opportunities currently exist?
Thank you. Can you hear me now? Thank you. I think the potential is really high. And for me, it's the way to go. We need to just begin to engender that by a community of practitioners, taking steps. It's just part of keeping the demand side high and getting some good results from non-state actors. I mean, from even state, because if you don't make demands, then you will never get there. So I see it as not just even something we can just do for individual cases, but for a collective, and also for demanding accountability with respect to implementation of certain international and regional human rights obligation with regard to protecting the trafficked persons, with regard to action to prevent trafficking, and with regard to also addressing the root causes of human trafficking and making sure that opportunities exist for recovery, for access to justice, and for compensation to victims or survivors of trafficking. This is often absent, and for African countries, yes, we always talk about the budget and constraints and inability to deal with, or people will say, oh, we are discouraged, the damages always awarded is very small, or the compensation. I think it's not so much about the quantum, but again, also getting something out that will form part of the emerging jurisprudence, I think. And for the strategic, I mean, the opportunities also for peer learning is there. Now we have this manual and guide, both the case law, a comparative case note, analysis to benefit from, that they can benefit from what has become successful elsewhere. Because again, there is opportunity, because when it comes to trafficking, I think the world or the political leaders are in unison in condemning and fighting modern human trafficking. Where there is a problem is in terms of economic will, in making sure that certain things happen, and also following through non-punishment of traffickers, because then you still see some who are trafficked, who comes back as irregular migrants, and who are further criminalized by states in Africa. I think also the opportunities exist now with the focus, again, even by the African Union and from emerging decisions that are coming from sub-regional bodies like ECOWAS. So I think once you have adequate domestic laws, even if you don't have, then it means that then there is no available remedy. Then they go international, and the African court is there. So once you have adequate domestic laws that respect the human rights of trafficked person, it becomes easy to access municipal courts to seek redress and to obtain justice for trafficked person. But where that is not possible, the state parties are of course bound to ensure that domestic legal or administrative system contains measures that will provide remedies for trafficked person, you know, including having the court, the procedures. But where it is not possible, then they go to international and regional bodies. The issue of adequate reparations for harm suffered, you know, restitution, compensation, these are things they have to think through. And the book already have enormous information in that. It builds the knowledge and it fills in the capacity and knowledge gaps that is required. So, so information concerning rights of victims, what kind of assistance that they require, legal, medical, psychological, are they available? Even absence of that could form a basis for a strategic litigation. That's why I said that we at times have to go beyond even individual clients to take on certain cases that would be declaratory, that will kind of restate or reaffirm the state obligations that are already there in extant normative framework at both international and regional level, and even sub-regional for some cases. So there is a lot that could be done, we can all do, that can be done in this respect. And but it's pulling resources and working together that will help, because we know some of these systems are very slow to work, and some will lack resources, which is a major problem. And then also the information, documentation. How do you get the evidence that they require? And the people are beginning to employ new technologies. And it's amazing that some of the people in the IT world, you know, big companies, they are now cooperating. Even there was a case I recall, they were able to provide all the information, whether by telephone, you know, because also they want to be seen as having the right work ethics that is against human trafficking in the supply chains. So we need also partnership, strategic partnership with those who are the gurus in the media and then new technologies, IT industry, because they can help a lot. Because you need cooperation with Interpol, and if you're doing it at individual level, state that is interested in prosecution, they use Interpol, they use all of those to gather intelligence. And if you're going to be defending the complainant, especially in terms of institutional action for compensation, you also need information that they will have to pay attention to how the process, in terms of the process of gathering that information. And I think there is also aspect of the guide that covers evidence gathering. And and all of that kind of enhances the potential for strategic litigation, and not just for strategic litigation, but for also successes, recording successes in that regard. Thank you.
Thank you, Professor Joy. Yeah, that your answer was so good. And like I said, perhaps in another life, I'll be one of your students, because I think more people had the opportunity to sit in their criminal law classes and understand some of these obligations and the connections with the human rights standards that come with it. We would probably have a much better justice system at play. To our participants, please feel free to ask your questions. Please raise your hand. We want to hear from you. We want to hear your questions, your thoughts, your comments. They're all welcome. I'm gonna jump back to you, Dr. Ruth, because there's a particular term that comes up in the guide that I think it would be great if you gave us an explanation. The guide uses the term justice as a form of care. Why was that an important term for this guide, and why, and what does that actually mean?
Right, thanks, Nobu. So that term actually came up again in conversation with Sophie, with Yasmin, with Elizabeth, and with the, we spoke to case managers and lawyers also at Willow International. And, justice as a form of care is something that came up very clearly to mean essentially just the conversation we've been having, that, justice doesn't have to be removed from care. If anything, the whole way of thinking about basket of care and the whole package of services that are necessary, need to be married with any justice agenda. It needs to be something that happens absolutely in tandem with any justice strategy. The other thing is because most survivors of trafficking do want to access justice. The barriers that we speak about, that we see, all of these challenges, it's really obstacles in the way of what they also want, right? They want justice, they want remedies. It's important for there to be remedies for rights violations. So justice as a form of care is a trigger also to lawyers to think about the person's life that's involved in this process of developing jurisprudence. Yes, for lawyers, it's about the jurisprudence or the outcome or all of that for most, typically trained lawyers. But the idea, that we're pushing for is to say, if what's happening out of court is also as important as what's happening inside of court, it's not just the judgment that will matter, it's the kind of transformation that will result from that judgment. And the victim really is at the center of that process and of all those decisions that are being made. So there are very practical steps that are given there for lawyers to think about even their own, how to reflect on their own biases, in just a conversation with a client. What is it about your own experience as a lawyer that you might be imposing? For instance, when the client is the one that's supposed to be making decisions about themselves, resisting the pressure to lead the process and allowing the victim's reality to actually lead that process. And even when the choices of the victim can seem inconvenient to the legal strategy, what does it mean to still nonetheless let the victim be at the center of that process? So and then also it also feeds into this thing of, a lot of lawyers are on the fence about, okay, but is this really our job? Shouldn't we just outsource to, work with people that are experts in providing psychosocial support and care? And this is true. It's about partnerships, it's about collaboration, but it's also about lawyers getting out of that comfort box of saying, me, I just know the law, and we're here to tell you about how the legal system works, so you fit yourself in this legal system. No, it's to say the way of lawyering itself needs to have a feminist ethics of care, the how that the lawyering is done. The lawyering itself needs to be trauma informed, and it needs to be victim centered. It's not just the substantive arguments, but it's the process, how it's done, and lawyers themselves being educated out of the ignorance of of thinking that, you know, the law is this neutral thing you can just apply to a situation, but them also learning to do trauma-informed approaches.
Thank you, Dr. Ruth. And this is so true, because our legal education, whether you are at a university or your postgraduate law school, the law is, the humans are never at the center of the law. You know, it's always just do the law, do what you're supposed to do, follow the statutes, you know. And I think what I really enjoyed about reading this guide, and for me, was questioning. You begin to question what are some of the things that you're taught in law school about what actually makes a good lawyer, you know, and what is your responsibility as a lawyer. Because obviously we are not psychologists, you are not those professionals, and it's necessary to form those connections and networks. But how far are you expected to go? How engaged are we supposed to be in this thing? And how far can you go? You know, the legal, ethical questions that so many practitioners will ask themselves when they think about working in human trafficking cases and this type of strategic litigation. And I'm very glad to say that I find that this guide really goes a long way towards answering some of those questions around what is justice and what is your responsibility as a litigator to the survivors. So to you, Sophie, my question is, when we talk about there's a buzzword term, you know, that's floating around, that is a phrase that people use now, at least practitioners in this area of law, and that phrase is the idea of a basket of care, and it's a term that is used when it comes to providing holistic care to victims. Can you please unpack for us what is a comprehensive way of providing a holistic care to a survivor and what that would look like?
I think I'll go back to my first comment about being trauma-informed and survivor-centered, that survivors will need different things at different times. And that whole working in collaboration, and what Dr. Ruth has said, I think one of the problems with lawyers most of the time is lawyers are normally not part of the process of case management. They are always at the side. And that means that, as you're saying, they are here dangling on the side, and they're not thinking about, as you're saying, that whole basket of care. So basket of care is looking at both a person's individual needs, and individual needs would focus on how has trauma affected them, and how can we remedy that, right? How can we make sure that they have access to the things that trauma has taken away from them? How can we make them access the thing? How can we make sure that they're also not vulnerable? I think Jacob mentioned it when he was talking about the fact that sometimes the criminal process is long and hard. It's not easy, it's long. When you're seeking justice, it takes time. Survivors are supposed to be on limbo while this whole process is going on. So when you're planning for it, also think about, like, how long, for 2 years, if you have a survivor that is going to be engaged in a case process, let's say that case is going to be 2 years, you're going to have to think about what can you do in 2 years. 2 years is a master's degree, right? If your life is normal, it's a master's degree, right? But you're telling someone to take 2 years, and we are not thinking about their housing, we're not thinking about their psychosocial support, we're not thinking about their community. If it's a survivor that has been, let's say it's not in their country of origin, it means they're outside their community. So you have to think of how am I going to make them belong in a foreign place? How do we connect them with other people so that their life actually continues while this court process goes on? And I think that's what most of us don't think about. So for me, I would say think about individual, think about family, think about community, and think about growth and leadership in the end, because we don't just want survivors. So much has already been taken from you as someone who's being abused, and asking survivors to actually lay down their lives so that, you know, we can test and see whether the system works. And at the end of the day, they're not guaranteed anything, is really hard. And that's why that whole conversation of remedies is important. Is the question is, what is in it for this survivor? What are they going to get out of this process, so that when they're investing this time with full knowledge of, I'm engaging, this is what I could possibly get, this is what I could not possibly get, and also the big picture. As I said, survivors have the ability to have this post-traumatic growth, but post-traumatic growth doesn't happen if the initial care has not been given. Survivors can be the best advocates, but they can also be the biggest limitation when this basket of care is not given. So let's invest in psychosocial support. Let's invest in ensuring that communities can actually take care of survivors. And then let's look at individual, like, what does someone need? Yeah.
Yes, thank you so much. Thank you so much for that, Sophie. I have one question. And that question is, could any of the speakers please kindly share their thoughts about the best way to provide support from a trauma-informed holistic approach when the trafficker is a family member? Thus, engaging in litigation disrupts their family, social network, and community.
I'm gonna try because I've been in such situations many times. I think each situation is different, and defining, one of the things that I've found out is that we define, when we talk about community is more of a sense of belonging, right? And one of the things that I've learned over the years is that the definition of family is really very different from one person to another. And essentially, most of the survivors that I worked with, sometimes immediate family, because of all that abuse, is really not, they really don't define them as their community. So working with a survivor from a trauma-informed lens would be to unpack that definition of community, to unpack that definition of family. And also, some situations are not going to work out. They're not going to work out if someone essentially is completely tied. But most of the time, the reason why people are connected to family and everything is because of things like someone is dependent on them for food, someone is dependent on them for identity, someone is dependent on them. So that's why when you think about care, asking someone to go against their family when essentially you are not providing a support and a community that could replace whatever they're losing is just demanding too much. It's too much of an ask. And that's why I've always criticized some of the interventions that we have in this space. They're very, very simple. They're not long-term, they're not intersectional, they don't have the feminist approach we all have, because trafficking in itself is focused on saving. And that usually ends after someone breaks down the door and they take you out. The long-term journey of recovery and developing a community around a survivor takes time. And what this person is mentioning here, it will take time. It will take time to actually work with a survivor to unpack that word family, to unpack that word community, and actually see whether you can build another community around them, another family around them. Most of the survivor leaders I work with talk about the idea of chosen family versus the family you are born with. I was abused within my family. So I recognize how this can play out in the real sense, where you completely lose or you lose some of the networks that are really important. But if these networks are developed in the process of providing care and community becomes a priority thing, then it's actually possible then to navigate with them. But it's really hard if you don't have the ability to actually unpack those things with the survivor.
Yeah. Yeah, thank you. I think Sophia has addressed it all, and you know it. I think in summary, just say that it's not one size fits all, and that's also the essence of having even survivors forums, and then doing a referral. Even as a lawyer, knowing these services exist, you can do a referral, and also having national referral pathways. You've made very, very important point. When family members are involved in the trafficking process, it's difficult to even talk about safe return of the survivor even back there, because then it won't be in their best interest, and then there will be a lot of problems. In fact, I've seen in my work around the world as the UN Special Rapporteur, cases where family members were implicated and they were sent back and then they got re-trafficked. I made a case of a girl almost re-trafficked 3 times or so because they said, you must succeed, you must earn us money. And they were, and then look at your colleagues, look at your mates. And so we have to always think about the kind of intervention and what may work for certain individual, and also bearing in mind the livelihood challenges, the human insecurity, and the problem that we are part of the push and pull factors that cost even the person to become, the trafficked person to be vulnerable to trafficking. I take, for example, I met some people in a shelter in one of the first countries I visited, and they were complaining that they were waiting for 2 years for criminal action. And meanwhile, they came here to earn money, and in the process, they got exploited and they got trafficked, some of them, into the sex industry. And they were like, we want to go home. Send us back. We are not interested anymore in pursuing this case, because at the end of the day, it's not going to help them. Just like we were saying, 2 years is a whole lot to do masters in 2 years. And then they are there and they think, being showcased in this shelter, oh, you have everything, you're fed, and then maybe you're learning tailoring. But that's not even really responsive even to their needs. And then I recall a girl I met also from Nigeria when I did a mission to Italy. She said, I can't even face my parents because they sold everything they had, in order to get her travel. And then the traffickers took, of course, advantage of her, and then she was trafficked and forced into sex industry for many years. And in that case, for example, she just decided to totally go off ladder. If you get her back, definitely the family will have to blame her for all their woes, and she will suffer tremendous stigma. So you have to find alternative. Wouldn't be just getting her back in Nigeria, getting her back to that family. So it's important to think there are difficult circumstances, difficult cases, but we have to take it. Each case deserves its own attention, and then also within the paradigm of what is effective remedies, because sometimes it's not enough to say, okay, restitution may not be possible or totally out of question, but you have to enable them in a way they will recover, and then have alternative families where families are implicated in that process. And of course, for some that do the forgiveness and reconciliation and all of that, they can also, those that focus on that type of work can also do their own intervention. Thank you.
Thank you, Professor Joy. So we are nearing towards the end of our panel. I'm just going to ask our panelists if there are any last burning thoughts on this particular issue, the topic of today. If anybody has anything that they would like to add, this is your opportunity. Failing which, if you enjoyed our panelists, please follow them on their social media platforms and find out what it is that they're doing. If you follow us on ISLA, you'll be able to see the different work that ISLA is doing around different topics. So this is the last webinar. Oh, I'm sorry, Dr. Ruth, do you have something to add?
Yes.
Oh,
yes,
sorry.
thanks. I was going to just thank in absentia Sky Chirape, who is a forensic psychologist that was also so instrumental in the development of this guide. And together, we spoke to Sophie and the other key informants with Sky. She's finishing up her PhD, so she wasn't able to join us, but really, just wanting to thank her, and to also, I think the point is that there's so much richness to gain when disciplines interact. That's what Isla learned. Like when lawyers are in conversations with, other disciplines that have a richer, other perspectives, really to disrupt what we understand as the norm. That's really been an amazing thing.
Thank you, Dr. Ruth, for that. Thank you to everybody who worked so hard on Isla's publications. We have a hand up, and I'm going to ask you, Raham, to keep your question to just 30 seconds so that we can wrap up. But please go ahead with your question. Hi, Raham, you've been unmuted, so you are able to ask your question. Okay, it looks like we have perhaps lost Raham. If you can unmute yourself. Okay, that's fine. We'll just move on.
Isla, congratulations to Isla and Hart. I think I may have to be signing off. Are you about to end?
Yes. We are.
Okay. Yeah.
Yes. So I want to firstly just thank our panelists for joining us today. Thank you for taking the time to join us. A massive thank you to Hart for partnering with Isla in these particular publications. And as Dr. Ruth has already said, to everybody who worked hard on providing information, the interviews, and just the breadth of knowledge that has been garnered from so many people, we appreciate it. This has been the fourth of 4 publications that Isla has launched in the last couple of weeks. And if you follow us on our social medias, you're able to see the different publications that we have launched. I'm not sure if I am allowed to have a favorite, but I must say that this is one of my favorites because I find it to be extremely useful in an area that is so rarely explored. But we have amazing publications, and if you follow us on all our different social media platforms, you'll be able to read them and become a better practitioner and just essentially know more about strategic litigation and human rights in Africa. And none of this work that we have done in the last couple of weeks would have been possible without the amazing ISLA team that has gone into doing this work, from obviously the people who wrote the publications to our IT team. Thank you so much to Mubin and the team for all our IT needs, to making sure that our webinars have gone without a glitch. Thank you, we appreciate you. And a very special thank you to our partners at African Feminism. They have done an amazing job of just partnering with us, helping us get our publicizing these webinars and coming up alongside with these amazing young feminists who are writing these incredible blogs on the different publications that were launched. So a very special thank you in particular to Rose Bell and Fiona for working with us. You made this entire process so much easier. And I think these publications and these launches have just been an amazing example of Isla's model of collaboration and partnerships all across the continent, to show that when we work together, we're able to achieve so much more. Thank you everyone for coming through. We've come to the end of today's webinar. Please go online, follow us on our social media, download these guides, share with a friend, tell your neighbors, tell everybody, share with your colleagues. This is such a useful resource. All the publications that have been launched are so useful. Follow us on social media, I'll repeat, so that you don't miss out on our next webinar series. Thanks again to our panelists for joining us. and we will all see you next time.